Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello and welcome to Hull on Estates. You were listening to episode number 678. I'm Stuart Clark.
And I'm James Macfarlane.
Good to have you here today, James. I think this is our first podcast together, so hopefully, it's a fun experience.
Yeah, I believe so. Thanks for having me. Really appreciate it.
Happy to have you here. I think we have an interesting kind of topic and case to discuss today. It's always, it's something which, at least, in the relatively uncool world of estates lawyers has been a hot topic for a few years now. And there's a recent case that we want to talk about that kind of expands upon and provides a bit more context to it. And that's the concept of minimal evidentiary thresholds in will challenges. And a few years ago, there was a case that caused much controversy or discussion, we'll call it, in the estates bar called SEPA. It was a 2017 case, 2017 ONSC 5368. And that was a decision of Justice Myers. And I'll call it in the great before SEPA, if you brought a will challenge and said, I thought my mom or dad didn't have capacity, or I thought there was undue influence, you could just kind of make that bald allegation to the court. And more likely than not, you would then get a lawsuit underway, and a lot of expensive productions would then happen. You're going to get medical records, going to get lawyer records, just going through the whole litigation process and putting the estate potentially to the cost of all that process and delay as well. And SEPA kind of said, well, wait a second, there should be some kind of minimum evidentiary threshold we want before we're going to send everyone on the cost of fact-finding missions, of documents, disclosures, et cetera, et cetera. And it was a decision of Justice Myers, as I said, and it kind of, got a lot of attention when it came out. And then it kind of, people weren't quite sure what to do with it. There's been a couple more decisions recently, including one called Johnson from the Court of Appeal. It kind of expanded on it a bit. Then recently, Justice Myers kind of had, I'm going to call it the sequel, but Justice Myers is sequel to SEPA. He's back on the estates list, and he has released a new decision called Jan and Yiannopoulos, 2023 ONSC 5412. And in it, at least I kind of read it as Justice Myers giving a bit more context and thought behind, well, what the heck does this minimum evidentiary threshold actually mean? And what does it look like? And what is the court's role in kind of trying to figure out what to do with this new process that we're kind of, all testing out together. So maybe, James, you can give us a bit of background about the Jan and Yiannopoulos decision.
Yeah, for sure. Thanks, Stuart, for the intro. So I'll just provide a little overview of this case. So starting with the parties, the applicants were two adult siblings seeking a declaration that their deceased father's 2021 will was invalid on the basis that he lacked capacity or was unduly influenced. On the other side, you have the respondent, who is the brother of the applicants, who benefited more from this 2021 will than they did. So one of the main assets that the father had was a dry cleaning business. So in a prior will, he left the business assets to his four children equally. And then in this updated 2021 will, he left the business assets solely to his son, who is the respondent. And the father's reasoning for doing so, as he explained in a note that he left with his lawyer, was that the respondent brother had essentially showed the most interest in spending time with him, taking care of him during his final years, and that the other children were not so much as present. So it's a really common scenario that you see very frequently in estates litigation. One child benefiting more than the others, those other children challenging the gift, believing that that sibling got more than their fair share. So this decision came out of a motion in which the applicant sought disclosure of financial, legal, medical records in a bid to show that these benefits were improperly obtained. So the main idea that Justice Myers addresses here it comes from a case called Neuberger, which was a 2016 Ontario Court of Appeal case. And it's really that in order for will challenge litigation to proceed, the applicant or moving party must introduce evidence that, if accepted, would bring into question the validity of the testamentary document. So if the applicant or moving party fails to meet what's called this minimum evidentiary threshold, then the court should dismiss the proceeding. But on the other hand, if the applicant or the moving party can introduce evidence that does bring into question the validity of the testamentary document, then a court will generally order that the proceeding should move forwards. So the issue in Jan versus Yiannopoulos is, did the applicants meet this minimum evidentiary threshold such that the litigation should be allowed to proceed? And His Honor held that the applicants failed to meet this evidentiary threshold, and he did not have much difficulty in making this decision. So in his analysis, it was mainly comprised of two parts, two questions. The first question being whether the evidence that the applicants put forward actually brought into question the deceased capacity or suggested undue influence. And the second part of that analysis being whether the evidence of the respondents and their responding materials constituted a complete answer to the applicant's allegations. So while I won't get too granular about the exact evidence introduced, because there was quite a lot of it, I'll discuss the general conclusions that His Honor drew from the supposed evidence. So with respect to the first part of the analysis, His Honor found that the applicants failed to offer any facts that, if accepted, would constitute suspicious circumstances or undue influence. And with respect to the second part, His Honor found that the applicants' allegations were successfully answered by the respondents in the responding materials. And what's more is that the applicants failed to deliver a reply affidavit, and they did not conduct a cross-examination of the respondents. So throughout this analysis, Justice Myers highlighted the difference between evidence and what he called spin. So His Honor viewed the applicant's supposed evidence as conjecture, assumptions, allegations. He found the applicant's materials to be drafted very disrespectfully, and he found that they really attempted to create a narrative of suspicious circumstances and ill intent without actually introducing any evidence that would bring into question the validity of the will. So those are some of my preliminary thoughts. Stuart, I'm sure you have a few things to add.
Thank you, James. That was great. And that's exactly it, right? And as James kind of mentioned there, Justice Myers kind of says there's a two-part kind of, process here. Part one being that, the burden's on the applicant to put forward some kind of evidence which accepted would put, the ability of the will, capacity, whatever the allegation is, if accepted would be true. But then there's a second part where the respondent has the opportunity to, answer that evidence and say, okay, fine. Well, you say, dad lacked capacity, and here's why you think dad lacked capacity, but here's all the reasons I'm going to respond to that and why it's not true. And Justice Myers kind of says like the role of the court in kind of, weighing, for lack of a better word, those two positions is interesting, because this isn't a full trial. You're not calling witnesses up to the stand. You're not having a fully conducted trial with cross-examinations, etc. It's not even a summary judgment motion, but it's something more than just, taking everyone at their word. There has to be some kind of credibility assessment done by the judge, both in, okay, here's the evidence that you're telling me, which, if true, may put the will into question, but then here's what your response is to that. And I'm doing some kind of weighing of those two positions and trying to come to a conclusion if I think there is, actual evidence that speaks to incapacity, undue influence, whatever it is that we're trying to get to. And as James kind of said there, it's exactly that, right? Like there's a difference, as Justice Myers says, between evidence and spin, right? So if there's actual evidence of incapacity, if here's doctor's notes, here's real circumstances that bring into this document into question, okay, there's a conversation here. Maybe we need to further explore this and go down the road of a full will challenge. But if all you're giving me is spin, and it's not, and you put in color and commentary on what otherwise may be fairly innocent, statements, that might not be enough to hit that threshold to say, I think you have enough here to you have that minimum evidentiary threshold to make me go through the whole will challenge. And His Honor at one point has a quote in the decision where he says, that basically that the applicants had cherry picked, or apart from cherry picked medical notes and spin, basically. There is no other evidence that he could see that actually called the capacity into question. So, okay, fine, even if I took that as true, which, I may not, the response that they've given to me, I think, is enough to make it so that, and ultimately he did rule here that you haven't met that threshold and you're done. And I kind of like this as well. I mean, this is, my Latin's never great, but he has a Latin quote in the decision I think is great, and it's the old concept of post hoc ergo propter hoc, which is basically after this, therefore because of this. The idea that, well, just because something happened after another event doesn't mean those two events are linked. So, for example, this isn't from the decision, but, relative timing does not necessarily indicate causation, right? So, oh, well, my mom moved in with my sister and a year later she wrote a new will. Well, those two statements don't necessarily relate to each other. Just because your mom moved in with your sister doesn't necessarily mean why she did a new will. It may explain part of it, but it doesn't necessarily follow. And lawyers can spin facts like that and put color commentary on them, which could cause someone to say, well, there's suspicious stuff going on here. Oh, well, my sister, my mom moved into my sister, and my sister then, put undue influence on her for a year until she did a new will. That's the spin and statement. You haven't actually given me any evidence that actually points to that. That's just your concept of the case. And I think it's an interesting concept. But yeah, so this case, SEPA, Johnson, a few others that have kind of come along that have kind of talked about this minimal evidentiary threshold. And I'm sure there'll be more to come. I'm sure we'll see kind of this law kind of continue to be a bit in flux until there's more cases that have kind of come out on it. But this case, SEPA, Johnson, all of them confirmed that this is the new way we're supposed to deal with these kind of circumstances, right? So if you can't, gone are the days in the past that you can kind of just baldly allege mom was incapable and expect that you're going to get a full will challenge. You're going to have to put some kind of evidence forward, your best foot forward, to at least get over that minimum threshold. And what that is in some, flux. But, obviously here we're going to give a bit more commentary of the kind of things the court is going to do and the weighing of evidence the court may do to decide that. And if you don't get over that threshold, you could be done from the start. That may result in some cases that maybe should have gone to trial, not going to trial. But I think the court sees the opposite being more true, which is that they're going to get rid of some of these kind of nuisance claims that are costing a lot of people time and money at an early stage.
Yeah, exactly. I think on balance, it's probably going to be a healthy development. Just trying to not allow some more frivolous or vexatious litigation, trying to reduce costs where possible, trying to make the best use of the court's time. And I think cases like this will put a greater emphasis on those principles.
Yeah, no, exactly. So it's interesting. So yeah, we're adding, more cases to our minimum threshold, whatever we'll call it. But it's an interesting read because it's a detailed analysis. And as James kind of said, His Honor did not take kindly to parts of the applicant's case here, and it was kind of summarily thrown out and criticized quite strongly, actually, of the kind of evidence they tried to put spin on, in his words, to get the will challenge going, and how it was flatly rejected by the court. But it's interesting to see, because you kind of see these cases are starting to develop of what kind of evidence may be thrown out and what kind of weighing of evidence may happen to get this minimum threshold stuff. So, but interesting case. We'll make sure the citation is posted on the comment. But as I said, the citation is 2023 ONSC 5412, Jan and Yiannopoulos. And the conversation continues on what the minimum evidentiary threshold is, and the new reality that we're all living with now in the estate litigation world. But no, I think that brings our podcast to a close. So James, thank you very much for joining me today.
Thanks for having me on, Stuart. Really appreciate it.
And if anyone has any questions, please feel free to write into us or to leave a comment on our blog. Thank you very much.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.